Hi everyone, welcome to the International Water Resources Association webinar on Bridging the Science and Policy Legal Perspectives. We are really excited to have you here today, and we have a great panel of academics and some nonprofits and associations, and we are going to get started in just 1 or 2 minutes. So if you need to take a last minute to grab a coffee or some water or whatever, we will be starting in just 1 or 2 minutes. So really happy to have you here, and we're excited to get started. All right, everyone, it's 2 minutes after the hour. I think I've given everyone who runs a little bit late enough of a time to show up. We're really happy to welcome you here today to the International Water Resources Association webinar on Bridging Science and Policy, Legal Perspectives. Today, our panelists include Rhea Stéphane, a water expert from France with the International Water Resources Association, board member, and the International Association for Water Law, AIDA. We also have Nico Sinon, assistant professor in sustainable law, regulation, and governance from the University of Helsinki. Deborah Curran, associate professor of law and environmental studies at the University of Victoria in Canada, who's waking up very early to be with us today. And Stefano Berci, a water law expert and the executive chairman of the International Association for Water Law. As most of you know, this is a webinar hosted by the International Water Resources Association. The IWRA is an international network of researchers and practitioners who work on a multidisciplinary range of water resource issues. We are a nonprofit, non-governmental, and educational organization. And this month's webinar is co-hosted by AIDA, since we have two members that are with us. They are an international association for water law, and they're really the preeminent association for people who are interested in water and law. The intersection of those. So IWRA, we provide a global knowledge-based forum for bridging disciplines and geographies by connecting professionals, students, individuals, corporations, and institutions who are concerned with the sustainable use of the world's water resources. And we're really happy to have everyone here with you today. Thanks for coming, tuning in. We have a really great panel. I really like the way we're bringing together some academics, and we have people from associations, and Stefano brings many years of knowledge from the FAO to us. So we're really excited to have a good combination of people here today. Our panel is going to talk about legal approaches to water and draws from papers that we had presented at the last World Water Congress in Cancun in 2017. These panelists will discuss the role of legal frameworks and mechanisms in the integration of science in decision-making processes and evidence-based policies, and they're going to bring us some insights on how to sort of bring law's flexibility and adaptation to scientific knowledge and new environmental, social, and economic conditions. So it's a very exciting panel, kind of rehashing and bringing up some of the same themes that we had in our last World Water Congress, and sort of setting a stage perhaps for our next Water Congress, which will be coming up later this year in Korea. So we are really excited to have everyone here today, and if the things that we talk about sort of bring up a interest that starts, you can please reach out and keep the conversation going. So if at any time you want to contact one of our speakers, you can look them up on the internet, send them an email. If you have a question about one of their slides, something that you hear today, go ahead and contact them. They're very friendly people. I vouch for this. Follow them on Twitter if you like. And you can follow the discussion that we're starting here on the IWRA LinkedIn webpage, where we will have this posted, and we will have some discussion questions for people to talk about. At the end of the webinar, we're going to record all this and have all the slides and all the PDFs put up on our webpage. So please go to our webpage and you'll be able to find it. So if you want to review the slides, review one of these discussions, or just to experience the whole wonderful webinar again, please go ahead and watch it. It'll be available for you there. So I'm just going to briefly explain the format of today's webinar. To start with, each of our panelists are going to give a short presentation, and then at the end we'll have time for your questions after all the presentations. So what you should be able to do is, even if you want to, as you hear a presentation going on, you want to ask a question, you'll see on the right side of your GoToWebinar control panel, there's a questions section. You can just type in the question and I'll see it, and then I can relay it to the appropriate people. And like I said, if you have a small question about a slide, a fact, or a figure, go ahead and direct that directly to the panelists and have that discussion there. You know, and then here in this time we can have questions that sort of bridge between the panelists and broader questions and themes that we want to hear about. So that'll be the Alex. Welcome. I'm so happy to have you with us here today. I think you're on mute. If you can turn your audio on. You know what we can do? We're going to go to Rhea. Rhea, the floor is yours. How about you can give us a presentation, and we'll give a few minutes for Dr. Godoy to get his microphone working. Rhea, the floor is yours.
Okay, thank you, Scott. Actually, I will only give an introduction, not a formal presentation. I'm talking here on behalf of my co-guest editors, Mara Tinino, René Martin-Nagel, and Owen McIntyre, because we had the pleasure to edit together this special issue of Water International. So as you said, Scott, this special issue was prepared by the International Association for Water Law, AIDA, and I'm talking here under the control of my chair, Stefano. So just to say a few words about AIDA, you already did, Scott, but just to add a little bit. So AIDA is a network of legal and policy specialists active in government, academia, and civil society who have a specific interest in freshwater resources, law, and related disciplines. And AIDA partners with a variety of intergovernmental and governmental and non-governmental institutions. So AIDA was a partner with IWRA in the last 3 congresses to ensure water law is properly integrated in the governance of freshwater management throughout the world. So this special issue has gathered the selected papers dealing with law and governance, which were presented at the last IWRA Congress in Cancun. AIDA has played an active role as a contributor to the development of the Congress by leading the delivery of the water law and governance track running through the program, soliciting presentations from high-level legal experts, and AIDA has also organized a special session related to the course AIDA had put together on greening water law. The papers published in this special issue address the Congress theme, which was bridging science and policy. The papers outline the role of law in water management and suggest solutions to make laws flexible and adaptive to changes in scientific knowledge and environmental, social, and economic conditions. We have here, each paper focuses on a different aspect and shows the interrelation between law, science, and policy in the complex and multifaceted water management aspects. And this interrelation pulls together in 2 directions, importing law into science and policy, while exporting science's approaches and methods to law and policy. So each paper focuses on a different aspect. We have here 4 of the authors who have their papers in the special issue, but we had 4 more authors. We had 8 papers in total. By the way, I can say that all the papers are free for download during 1 month, so you can access them during 1 month freely. And so besides the paper that you will hear about during this webinar, we had a paper by Bolado and Patera dealing with a recent legislative evolution in Spain about the urban planning and the water requirements which influence this urban planning. Two papers deal with groundwater, and we had a viewpoint by Eric Garner providing key information on the management on the successful management of aquifers, whether transboundary or not. And Elena Quadri focused on the Nubian sandstone aquifer system, one of the biggest transboundary aquifer system in the world, and the evolution of the cooperation in this transboundary aquifers. There was also a paper by Moscoso and Larson comparing forestry management in Ecuador and in Arizona, and how these two programs about forestry management in these two areas influence and suggest lessons for water management in general. This is my introduction on the special issue. I would like to leave the floor to the authors, and I will. I can also answer questions if necessary. Thank you for listening.
Excellent. Thank you so much, Ray, and thank you for giving a little overview about the genesis of this special issue and the role that AIDA and IWRA have played together. We have a lot of the same members and a lot of interaction between the two groups, which I think is great, creates some great synergy. I think we're going to turn the floor over to Stefano. Stefano, we can hear from you, the chairman of AIDA.
Thank you, Scott. Let's see. Yes. See. Excuse me.
Oh, that looks good.
Okay. Now let me see if this works. Well, good afternoon or good morning, wherever you are, whoever is on this, attending this webinar. Let's see if I can manage to call up on screen my presentation. Okay, now let's see.
That looks good. Beautiful.
Yeah, but I have to get rid of a few features here. Okay, let me see. Okay, now let's see if this works. Okay, I'm sorry. Okay, here we are. I'm sorry, but excuse me if I keep fiddling with this. Oh God, can you please stay? Let's see. Now I don't understand.
It looks quite good. I think you can just go ahead and if you can speak, just.
Yeah, anyway, the idea is, let's see, because I need to move to the next.
Can you just tap the next button?
Yeah, this is what I'm trying to do, but nothing is happening.
Well, I can hear a little buzzing. That's probably not what you're looking for there.
I'm sorry, it was working fine when we tested it.
Yeah, it was. We just tested it like an hour ago. Everything looked good.
But now it seems that I'm unable to operate it. I mean, I have the title.
What we can do, we can go to Professor Curran, perhaps, and then gives you a chance to test things out there and see if we can get everything working on your side. Would that work?
Yeah, sure. I'm very sorry. I'm embarrassed because it worked very well when we tried it out, and now.
No problem at all. It's no problem at all. Professor Curran, are you feeling ready to pinch hit there? Good.
Yes, absolutely.
All right. Oh, that looks good.
Great. And can you hear me all right?
Sounds great.
Okay, great. I'm sorry that Stefano isn't going first because he provides a good overview for what we're all going to talk about, but perhaps what we talk about will make more sense then when we come back to him. From my perspective, good morning, everyone. I'm here in Victoria, BC, where we have had a winter drought for the first time on record, and the recent forecasts coming into the summer are for extreme drought conditions. So we are very much living the adaptation challenge, I guess, that I'm going to talk about for the next 10 minutes or so. And what I mean by adaptation, or I mean it in a water law sense in a very, very narrow way. All I'm looking at are the way in which we can adapt water licenses, so existing entitlements to use water under provincial law here in Canada. So under our constitution, water is not mentioned, so that's our federal law. Water isn't mentioned, so each of the provinces, our 10 provinces, and then we have several territories as our subnational regulatory bodies for the environment, they all have different water law regimes. And usually they would give out licenses, as is common across the world, to use water. And so the question then becomes, as we get into more drought conditions, at least in the summer months when the farmers and everyone else wants to use more water, what is the potential for actually adapting those licenses to reflect the reality of lower water use? So that's very much what I mean by adaptation. So I'm just taking a very small slice, which I think gives a good indication of the larger picture of water law in Canada. So what I'd like to do is just give you a tiny bit of context about Canada and our watersheds and water, then give you a little bit more about the 4 different legal regimes or ways that we undertake water law in Canada. And then my third point around approaches to adaptation are really the results of a cross-Canada scan of the way in which we set up our different water licensing regimes, and then how those regimes allow license entitlements or the ability to use water to change over time. So how can the state, each of the provinces, actually go back and say to a water license holder, oh, we're now changing what you're allowed to use because of climate change and different hydrological conditions. And then I'll just provide a few conclusions. So to start off, as you know, Canada is a very large country. We have many different drainage basins. Most of our water actually flows north, so it does not flow south and is not in and around where most of the population is, the human population. So the vast majority of water flows north and is not accessed except for some large industrial uses like hydroelectric. We have very diverse ecosystems and watersheds. In particular, where I live in British Columbia, we have the only desert-like climate in Canada in the Okanagan Basin, and that is just 400 kilometers away from the coastal temperate rainforest. And we have in British Columbia the largest intact coastal temperate rainforest in the world. So you see in very short distances, we have huge diversity in the way in which water precipitation falls and the way in which water flows. Also, what's important to notice in Canada is that underlying our water law regimes, we have often unceded and unacknowledged Aboriginal rights and title. So according to our Constitution under Section 35, we acknowledge and affirm Aboriginal and treaty rights. I won't get into what those mean or what that means, and we don't have a particularly strong statement from the courts yet about what that means for water. What we do know is, however, there are increasing conflicts between Indigenous communities in Canada and government decisions about water allocation and use, and that's becoming much more prevalent. We see a lot more statements or declarations of Indigenous law around water use in British Columbia in particular, and also pursuant to treaty rights across Canada. This slide also shows you some of the changes that are occurring hydrologically. So you can see in the top left, that is our drought map for British Columbia, and in the summer of 2015, in the lower left of that map, you can see that the rainforest, so around Vancouver and Victoria, where I live, we were in actually stage 4 drought conditions. So the rest of the province was okay. And in fact, the Okanagan, which is in fact a desert, had dry conditions, but the part of the rainforest anyway was in severe drought conditions. And then finally, the bottom slide is a local government here on Vancouver Island that is acknowledging the water changes that they are experiencing, and you can see that they're labeling it the new normal, and they are very much, this is a web page from their website talking about what they're going to do with the new normal, or what they're going to do with extreme flood conditions in the wintertime and then much less water in the summer for what is an internationally significant coho salmon run. Right now we're seeing flooding for the second year in a row on the Ottawa River that is flooding extensive neighborhoods that have not occurred before. So the thought is that after this year, there will be a remapping of the floodplain in much of Canada, and that will be a federal undertaking, and that will have a significant impact on the real estate industry in certain areas. And then my final bit of context is just this very new report that was released this spring by the federal government talking about Canada's changing climate, and it mimics but amplifies a lot of what we already understand, simply because we are a northern country and therefore we're going to experience more extremes than in other areas. So there's an amplification of warming at high northern latitudes, which means Canada's climate is expected to warm more than the global average. It's projected to almost double the rate of global mean temperature. So our extreme warm temperatures are becoming hotter, while extreme cold temperatures have become less cold. And we see a very increased risk of fire weather in parts of Western Canada. I mean, in BC, we've been in virtually a forest fire emergency for the last 3 summers, and this will spread to the rest of Canada. In terms of water, precipitation changes in Canada are also closely linked to global scale changes, such as the overall intensification of the global water cycle. And we'll see increases in high latitude precipitation, the intensification of precipitation extremes in other areas. But the most significant observed changes in freshwater availability will be in the seasonal distribution of flow, in particular in many snow-fed catchments. So winter flows have become higher and are becoming higher, and the timing of spring peak flows has become earlier, while there's an overall reduction in summer flows. So as you can see from this very brief introduction, we're living the adaptation imperative in many parts of Canada already. And part of that is asking, when we do have low flows and drought, how can we adapt our water licenses such that they can reflect an ecological and a hydrological reality, rather than carrying on as a paper fiction where people can't actually exercise their water rights. So very briefly, in about 1 minute or less, I just wanted to let you know that in Canada, we do have what we've sort of characterized as 4 systems of water law. And while that may seem extreme, we're a very large country with different hydrological conditions, and our provinces are very large, so often as big as some of your countries. So it doesn't seem that disconnected a lot of the time. So the 4 systems are, most of you would be familiar with a riparian system, and we've modified that with licenses in much of eastern Canada. So sort of Ontario to the east is what's used in those provinces. The civil law, of course, is alive and well in Quebec, and so that's the civil law system that's used for water management in the province of Quebec. From Manitoba West, except for Saskatchewan, we use a modified system of Western water law. So you might be familiar with that from the United States, where it's the first in time, first in right priority system. Those who got their licenses first have priority over those who came afterwards with obtaining a license to use water. And then finally, we have some hybrid administrative type systems in the Northern Territories and then in Saskatchewan. So it's basically a water agency that manages the water and has a lot more discretion than in the other systems. I think it's really important to note, though, in Canada, we have no constitutionally protected property rights. So unlike the United States, so we have a lot more regulatory latitude or discretion. So water licenses are not seen as a property right. Therefore, they're seen as a regulatory entitlement, which should then allow us to change them over time with certain restrictions. Okay, getting then to the main analysis of these various systems or these various water regimes, water law regimes across Canada, there are essentially four different ways or four different approaches to adaptation. So going from having no ability to adapt to adapting in the public interest. And I'll just go through those and just give a couple of examples. So the only province that has no ability to adapt is that of New Brunswick, which primarily relies on groundwater licensing. The second one, hold back with a water transfer, is only in Alberta. Alberta is the only province in Canada that actually allows for a water market or water transfers in the sense of essentially a sale from one licensee to another. Otherwise, licenses tend to be attached to either land or an undertaking, like a hydroelectric dam or works like that. So in Alberta, you can hold back 10% of a water allocation, as in the volume, upon a water license transfer, but that has to occur under a water plan or under provincial direction. The third way that we can allow for adaptation is pursuant to a plan or a comprehensive review. And this is only seen, well, it's primarily seen in BC and Quebec. So for example, in British Columbia, you may amend a water license if the water is not used beneficially or upon review of an area of water licenses, but this only comes into force 30 years after our new Water Act came into force, or pursuant to a water sustainability plan. So if there's an entire plan in a watershed area, then that plan can identify adapting or clawing back water under license. Where we mostly see the ability to adapt water licenses is under this broad category of in the public interest. So for example, in Alberta, you may cancel or suspend water licenses for emergencies, public safety, or significant adverse effects on the aquatic environment. In Saskatchewan, you may cancel or suspend if water is no longer needed or in the public interest. Likewise, in the same provision as in Manitoba, but with the addition of, or if you want to allocate that water to a higher use, a higher priority use. In Quebec, you may amend or cancel in the public interest. And then specifically in the St. Lawrence Basin, you have to assess the cumulative impacts of water withdrawals and consumptive uses every 5 years. So that's more of an integrated approach. In Nova Scotia, you may amend a water license if you have new information relating to an adverse effect or if an adverse effect does in fact occur. In Prince Edward Island, you can amend for the protection of the environment. And then Newfoundland has a very broad provision that encompasses some or all of the above. Just a final note about compensation, since I did bring it up that we don't have constitutionally protected property rights. We fall somewhat evenly across Canada under our water laws around whether if you do amend, you have to compensate, or if you amend, you don't have to compensate. So for example, in British Columbia, we have a very strong new no compensation provision under Section 121 of the Water Sustainability Act. There is no compensation payable for effects caused by a change in authorization, unless that reduction is contemplated under a water sustainability plan or it's ordered in a regulation. This is in contrast to places like Alberta, Saskatchewan, Manitoba, and Newfoundland, where you must compensate for losses that are the result of a cancellation or amendment, in the case of Alberta, for adverse environmental effects. So in conclusion, oh, you know what I didn't mention earlier on, which I meant to mention in the context, all of this potential for adaptation in our water law is going on in a context where we have very little scientific information about water itself. So in some specific areas like the Okanagan that's very dry, in the Great Lakes, which are subject to transboundary water agreements with the United States, there is a good amount of scientific information, but generally we're often flying pretty blind in making decisions about water. And I think the paper and some other papers I've written point to those appeals, the court decisions and the Environmental Appeal Board decisions that really show the lack of science that is going into decision making at this point in time. So we need a whole lot more science into law. We need to increase our water rents and pay for that science to have a much better concept about how water is interacting, and in particular the interaction with groundwater. We also have to approach this in a much more integrated way. So rather than focusing on individual licenses, we need to do a lot more watershed planning and then look at cumulative impacts and where we can actually allow water to be used in creative ways. There is real potential for this comprehensive license review, which is allowed in British Columbia. It's not named anywhere else. And so it'll be very interesting to see. Unfortunately, we have to wait 30 years or now 25 years to see how that will play out. But there's a lot of potential for example, under a watershed plan, doing an entire review of all of the licenses in the watershed and then affecting some reallocation through regulation based on that assessment. We are also seeing some negotiated agreements between First Nations and state governments. So, for example, the Nicola Chiefs here just outside of Vancouver, so sort of about 200 kilometers from Vancouver, in quite an arid area around the Merritt region, they have signed a memorandum of understanding with the province of British Columbia to undertake a watershed planning process and to try and work out how to co-govern the water in that particular area. So we see more negotiated agreements, and I often point to the Klamath agreements in the United States, which border Oregon and California, and those are interesting examples of how to resolve very complex and multi-party water management problems. And then finally, we simply need to change the way that we do license allocation moving forward. Just speaking for British Columbia, virtually no licenses except for hydropower and now oil and gas have any end date on them. So there is no ability to actually on a regular basis or a semi-regular basis go back and assess whether they're still reflect reality, a hydrological reality. Likewise, we only recently have a requirement to consider ecological flows when we do give out licenses. And so these are some very basic legal principles that link to science and link to, as I put it, a hydrological reality that will allow us to adapt over time to these very extreme precipitation and flooding conditions and drought conditions that are coming our way over the next 50 years. Thank you.
Thank you so much for that presentation. That was really good, and I like how you framed that realities aspect, because I think sometimes we sort of have a reality on paper, the policy or the law, but that doesn't always connect with the reality that we're now experiencing. Perhaps it's structured around a different reality or an older perceptions, but it doesn't really reflect the new normals that we're experiencing. So I think that was really good, and I appreciate the way that you're able to frame the several different water regimes within Canada. Sometimes people can get tracked into the idea of having just one or two regimes, but forget that there's such a variety even within one country. So I like that, appreciate that. Stefano, can we try you again?
Yes, thank you, Scott. I think, let's see. Okay, show my screen. Okay. Okay, now let's see. I think I know what I did wrong.
All right.
Okay.
Looks good so far.
Yes, looks good so far. Let me see if I can. Okay. All right. So actually, I enjoyed very much Deborah's presentation. Deborah, I'm very intrigued by all that you said, because actually you provide a very compelling zoom in on one of the aspects that I have addressed in my own presentation. In actual fact, what my presentation does is actually sort of look, put on the lenses of climate change, or the need and the requirements and the push for adaptation and mitigation driven by climate variability, and read, how could I say, some of the contemporary trends and developments in contemporary water law from a comparative perspective, from the lenses of adaptation to climate change and mitigation of the impact of climate variability. So in that way, this presentation takes on or draws upon the paper that is featured in the special issue of Water International that Raya illustrated at the start. So it is not actually that paper, but is, if you like, is a reading of that paper in the light of, from the particular lenses of adaptation and mitigation, adaptation to of water allocation patterns and rights to natural water supplies that become dwindling and unreliable due to climate variability, but also the mitigation of the impact of climate variability on water supplies, on the availability of water supplies for allocation and use, and the rights that underpin them. So actually, what Deborah Karen illustrated is essentially a blow up on the very first item, adaptation, the potential of water law for adaptation of water allocation patterns to changing, dwindling, unreliable natural water supplies in Canada. Now, let me try and put it in a rather larger perspective from the viewpoint of comparative water law. In terms of adaptation, now, what instruments are available in contemporary domestic water law? One is for sure the legal status of water as public property, public domain, or different configurations that lead to the same result. That is to say that water comes under the scope of the allocation authority of the government in the public interest. And this is a well-established trend in contemporary water laws. And with it comes the systems of government-administered water abstraction permits, concessions, and licenses, which is also a very well-established trend. Now, these the potential for adaptation, the adaptation potential in particular of water abstraction permits, licenses and concessions will be all the greater if permits are time-bound, i.e. they are not granted for an indefinite duration. And here is something that actually caught my attention when Deborah, the previous speaker, said that in Canada, I don't recall whether in all provinces, but anyway, there is this practice of granting hydropower development licenses for an indefinite duration. Okay, this is surely not something that works and goes with, or that enhances the adaptation, the adaptive potential of permit systems. So this adaptive potential is all the greater if permit systems are time-bound. Now, this is generally the trend nowadays in much contemporary water laws, is to grant, to have these permits granted for a definite period of time, at definite duration. And if permits, licenses and concessions are made subject to periodic review and variation by government in response to changing circumstances, as also was illustrated by Deborah Karen with respect to Canadian provinces. And these are both well-entrenched features in my own reading of contemporary water laws. Now, what is interesting, and an interesting new feature, if you like, of water abstraction permit systems that enhances, in my view, their adaptation potential is a shift from fixed volumetric or flow allocations to variable shares in the water that is available at any time. You have this rather sophisticated system, if you like, of abstraction licensing well developed in Australian jurisdictions where water is scarce, and the impacts and effects of climate change and climate variability have prompted the development of rather sophisticated approaches to dealing with variable, unreliable natural water sources, water supplies. And but this shift from fixed volumetric flow allocations to variable share or share-based allocations is also visible and is under contemplation, if I'm not wrong, in England and Wales. So it is not just a feature of Australian dry jurisdictions, but it's also something which is under consideration elsewhere in more humid climates. Now, and again, this has been alluded to and illustrated by Deborah with respect to Canadian provinces, Canadian jurisdictions, with the downscaling, the variation, the downwards variation in the quantum of water allocation comes the issue of compensation, which is something that I found at least addressed differently, as also illustrated by Deborah in the context of Canada. The response of water laws is mixed on this issue. Some provide for the possibility of compensations. Other laws simply duck the issue altogether, don't mention it, while others still may deny all compensation altogether. But it's an issue that looms large in this particular context. Now, when it comes to the mitigation potential, to my mind, water laws, in my own reading, and this is a very personal reading, of course, water laws, with the contribution of other laws, can contribute to mitigation of the impacts of climate variability on available water supplies through mechanisms that, on the one hand, improve the efficiency of water allocation. So they make a more efficient allocation of available water, conceivably lesser and lesser available because of the effects and the impacts of climate change. And protect water resources from pollution, because if you have reliable amounts of polluted water that are good for no use, obviously, is tantamount to having lesser and lesser water available. And minimize, and this is also sort of a cutting edge aspect of contemporary water law, that minimize the impact of human activities on the natural water retaining or water regenerating processes that occur overland and underground. This last point in particular has to do with this elusive, if you like, interface between land and water, which is readily apparent when it comes to groundwater, but is there at work also when it comes to surface water, that tends to be lost on much mainstream water legislation. Let us have a close look at this mitigation and how these mechanisms work. Now, efficiency in particular of allocation, and this is something that you can detect from many contemporary water laws, is pursued through a variety of mechanisms, such as water abstraction charges, the user pays principle, controlled trading of water abstraction permits and the likes, and Deborah again has alluded to this in the province of Alberta in Canada, where water markets, water trading is allowed. And 9.9 times out of 10, the trading of water abstraction permits is controlled, is practiced under some forms of government control to avoid certain effects like third-party effects or environmental, unwanted environmental effects and other, let's say, negative externalities, if you like. That's why I say the general trend is to, yes, allow trading, but under controlled conditions. And financial and other incentives to water recycling and reuse. The control of water pollution, as attested to, as seen in much contemporary water legislation, point source water pollution is regulated by government-administered permits, time-bound permits, licenses for the discharge of wastewater to natural water bodies or underground, complemented with effluent and or ambient water quality standards, and with wastewater discharge charges, so charges for the privilege of discharging waste to freshwater bodies. In implementation, it's a manifestation, if you like, of the polluter pays principle. Pollution of water from diffuse or non-point sources, and in particular, I think of the surface runoff from cultivated lands and percolation of water laden with pesticides and fertilizers underground with a polluting impact on groundwater, is addressed differently through essentially by shifting the focus from water from water, if you like, to the activity that leads to diffuse pollution. And this is why, and this is where other laws than water laws come in the picture and contribute to dealing with controlling pollution from diffuse sources. In particular, the targets of regulation are cultivation practices, including the sale, application, and use of pesticides and fertilizers. And you see this reflected in water laws, but also in other laws as well that complement and work at common purposes with water laws. Now, when it comes, and you see this also, this working at common purposes now more and more in relation to minimizing the impact of human activities on the natural water, what I call water-friendly natural processes that occur overland and underground, and is echoed not only in water laws, in the more, how could I say, the more advanced contemporary water laws, but also in particular in town and country planning laws. So it's not just a matter for water law alone, but it's a matter for water law working in combination and coordination with town and country planning laws and vice versa. So mechanisms of this kind include zoning. In particular, I'm thinking of zoning of groundwater recharge areas where you have this this relationship and this interface between what happens over land and the what happens, below the land in the in respect to groundwater and the formation of groundwater and the replenishing of groundwater. And also these other mechanisms, requirements that the impact of land uses on water sources be factored in land use planning determinations, also with respect to mining, for instance, and other uses of subsurface space, where you see in the more advanced water laws, you see these mechanisms at work mirrored in equal and equivalent mechanisms found in town and country planning laws, so that the two sets of laws, water laws and town and country planning laws, or also mining laws, work at common purposes. The common purpose of minimizing the impact of human activities on the natural water generation or water replenishing natural processes that happen over land and underground. So I think this is my, this is I will stop here, and I offer you this. I'm going to say this is not this is an attempt, if you like, to put a particular lenses on much contemporary groundwater legislation. I mean, water legislation. Not that you find many water laws, at least I've not seen, that deal or that address squarely the issue of climate variability, climate change with very particular, specific or sophisticated mechanisms, as much as seeing what mechanisms already exist or are developing in contemporary water laws, and to the service of that can facilitate the processes of adaptation to climate change and mitigation of the impacts of climate variability. Okay, thanks a lot. I will stop here.
Well, thank you so much for that great presentation. I really thought it was a great way to cover a lot of different insights, and I think it was also a nice way to sort of highlight the collaborative nature of the work between AIDA and IWRA. So I really appreciate that presentation. That was good. Let's go now to Dr. Goodroy Foundes. Alex, are you there? Are you on mute? Is your microphone working there? I see you're off mute, but I don't hear anything. Oh, I don't hear a thing.
Yeah.
Ah, here we go. That's a word.
Hello. Hello.
Yes.
Hello.
Yes, you sound great.
Oh yeah. Can you hear me, Bernie? Can you hear me?
Yes, I'm gonna make you the presenter, and you just accept this when it pops up on your screen.
Yes.
Excellent.
Excellent. Okay. Let me.
Yeah. There you go. Just make that presenter mode there, I think. Podium mode is the.
And can you see the presentation? Okay.
Yes, yes. What we'd like to see is the full slide, full screen. Right here, we're seeing the next slide, and we're seeing the text as well.
Yes, and first of all, nice to meet you. To me, it's a really honor to speak today and stay with you. And I would like to talk about more research. Maybe more research is more technical, because we started this research 4 years ago trying to understand the water conflicts in Chile. Because
can you make the slide full screen, please? Just so we can see. So it fills the whole screen, your whole screen. I think maybe if you click the buttons there at in the upper. Yes. The Spanish is a little tricky for me, but I can struggle along. There you go. That looks beautiful. There
yes.
You go.
Can you see the presentation?
Wonderful. Please. Continue.
Okay, I'm sorry. And this is my first time talking in this kind of webinar. So I would like to talk about the research, because the research starting 4 years ago, trying to understand and what are the drivers of the water conflict in Chile. As you know, I am not a lawyer. I am an PhD in chemical engineering. So for me, the water conflicts is just a problem of the balance of masses and balance of energy. But here in the discussion in Chile is about the problem in the water scarcity is because we are suffering on water scarcity from 10 years ago, because we are suffering impacts of climate change, and all people is trying into the political discussion, trying to reform the water code or reform the constitution, because all people think that the problem in Chile is not the climate, the problem is the regulation, and just all people into the political discussion is trying to and moving ahead to reform the constitution. Why? Because in Chile, in Chile nor water code and is promoting the water like a private property. Indeed, the water code in Chile and the water market in Chile is very famous because in the beginning, despite of the water is for public uses, the government allocate water rights for any citizens and companies, and after that, the people can trade the water right into the market, like if the water was another kind of good. So all people is fighting into the political discussion about if we need or don't need an reform of the constitution, or if we need to reform the constitution because the problem is the water is like a private property, and all people is thinking that the water is a private good, but it's not true. So, and in our approach was trying to understand what are the drivers behind the water conflict in Chile. So we define the conflicts, and when you two parties cannot resolve a problem about the water right trading, the people is going to the court to resolve this problem, and we trying to sorry. Yes. So our approach was try to understand the water conflicts and in Chile, understanding and what happened with the water rights allocated from the government in correlation with what happened with the lawsuit or the sentence from the Supreme Courts or the different courts, and what is the correlation between water scarcity, water rights, and what is the discussion into the courts when two parties are going to resolve a problem when they're fighting for water rights. So we talk. The problem is beyond obvious increase of conflicts due to the water scarcity. There is a lot of problem on governments that prevents the water use becomes a source for the conflict. So our question was, what is the driving that the people is fighting for the water rights that is going to the court? So how we can and take an approach to understand what is the issue that the people is talking about into the court, and what is the real problem what the people is going to fight in different courts or in the national courts. So what is the evidence is the problem is the water market. In the beginning, despite of the water in Chile is for public uses, the government allocate water rights for any citizens, but the people can use the water right like a private good. And so when the people has a problem, the people is trying to resolve the water scarcity into trading water rights into the water market. So the government never is involved to resolve this problem. and just the government, after the water allocation, release the water market, and those people is thinking that, okay, if the water market is the solution to the water conflict, what is the role of the government? So we took a lot of information from the public registry of user organization. We get information from the people working into the government, because one question is, okay, what the government is doing in trying to resolve this problem, and we use the registered water user rights, and all this kind of information is a public information, and we are starting creating the maps. In this case, you can see that into the map, in the red color is the high intensity of the water use of right and allocated from the government. In this map, you can see that in the red colors is where the government has been allocated a lot of water rights. Indeed, you in the map of Chile, in the right side, you can see that you have a specific commune where the water right was allocated for the government and over the water flow into the watershed. So our first and results and in this kind of map is the government is allocating more water rights, and that is not correlated with the water availability into the different watershed. So the question is, okay, why the government is allocated more water rights than the water flows? And one hypothesis behind is, okay, maybe is because the government doesn't have a good information from what is the water flow into the watershed, or the capabilities and skills into the government are not enough to allocate water right and resolve the problems. So, and if you compare these different communities and administration, the people is allocating more water rights than the water flow, and this is increasing throughout the years and until today. And the problem is that if you are understanding what is the role of the government, it's incredible that the government doesn't have any influence in to resolve the problem for the water rights. Despite of the government, we have 52 entities and responsible to the water rights, and if you compare the different the different uses of the water right, you can see that the consumptive water rights is higher than the non-consumptive water rights. So what's the mean that the government is allocating more water rights than the flow into the watershed, and two, it is not correlated with the uses, because finally is the water market who is resolving who is taking the water right in hand. And if you see the number of the registered of the water right into the government, you can see that throughout the time in different part of the Chile, the number of the water right is going up in after 2005. What happened with that? And it's interesting that in the first reforms of the water code in 2005 opened the opportunity to the people to go into the courts in different regions. Before 2005, all people when was fighting for water rights and has the opportunity to just go to the Supreme Court in Santiago. But after 2005, the government opened the opportunity to the people, put different laws in different regions, and you can see here that there are correlation between water rights in different regions and number of the water rights allocated and law. As you see here, and this is the average requested flow, and the average requested flow is over and beyond of the watershed capacity in different regions. And here, if you take the number of the and you correlate how much water was allocated for water rights and what is the consumption, here you can see that the supply and demand, they are not correlating between them, and the market maybe has more water than the supply and demand too. So our methodology was, okay, maybe if we talk the legal actions and compare the number of the water rights, you can see in the orange and graph that the number of the water rights is going up, despite of Chile is suffering and water scarcity. So what's the means that despite of the evidence and physical evidence showed us that in different watersheds the water flow is go down, despite of the government is allocated more water rights because the government is not correlating the water flow and the water needs. So despite of the evidence is we don't have more water into the watershed, the government continue bringing more water rights, and this is not correlated with the physical water into the flow. But in the blue graph, you can see the number of the judicial rulings. What's the means that how many lawsuits you can find into the court. Before 2005, nobody was fighting for the water rights, but after the water reforms code, and when the people can go to the different courts to put the lawsuit between them, you can see that there is a correlation between water and a number of the water rights and the number of the lawsuit into the court. What's the mean that? Once the government is allocated more water right that they flow into the watershed, and second one is this is creating a big problem because the people has more water rights but that doesn't have the real water in their hands. So finally, if we use 3 maps into the court to understand, okay, if the people is going to different courts in different levels and to fight for water rights because the people has the right but doesn't have the real water, but finally all people is going to the Supreme Court in the red bubble. All people is finally is going to the Supreme Court because nobody is resolving the problem, and this is the problem. Finally, over 1,000 court rulings was processed 1 year ago. So, and the second point was, okay, we need to try to understand what is the reason because the people is fighting. And here you can see that through the years, and the trends in different regions is going up, and the statement into the lawsuit is every time is more complex. We talk the court rulings, and here you have the corpus of the different sentences from the Supreme Court, and we use data mining and tools. We use different mathematical protocols to understand what is the more trending topics that the people is discussing into the Supreme Court, and we use different approach and software package to understand what is the topics, what is the people is talking about into the court. And we use different strategy to classify the code, the different code, mining code, water code, cyber code. So the idea was to understand what is people talking about the water right and what is the real conflicts. The first result is, okay, and over 73% of the legal claims is against the government. Why? Because the people, the discussion into the course is the people is saying that the government is not allocating the right quantity of water per any water right. What's the mean that the government is providing more water right than the real water? So the people is going against the government, trying to obligate to the government to regularize the water right and try to reduce the quantity of the water, the real water, to the real and water right for the government. And we use 3 maps, and we analyze the jurisprudence, and we know results and find out we can find different topics over the time. And before the 2000, the year 2000, the main topics was related to the main cause of the conflicts before 2000 was the protection of the property and the environment. So before 2000, before the reforms, we can say that the people was fighting to protect the private property on the water right. After the reforms, the main cause of the conflicts is the regularization of the property, and after 2010, the main cause of the conflicts is the exploitation of the groundwater. So research is showing us that in the beginning, when the government was allocating water rights, the location of the water right never was correlated to the real water into the watershed. The government is allocated water rights according of the water needs of the demand, but never was correlated to the real water into the watershed. Two, we calculate how many lawyers was working into the government. Into the government just are working around 15 lawyers, when the 73% of the total lawsuit into the court is against the government. So the government doesn't have the capacity to resolve the legal problems. And four, throughout the time, the evolution of the conflicts, the driver has been different. In the beginning, was the conflicts was driven by property. The question was, okay, who is the owner of the water? The people, the people asking for water rights, or the government, or the private sector. After the water reforms code, the discussion of the conflicts was different. Was about the regularization. What's the means that the government allocate a lot of the water right without correlation with the physical water, and after that the people was fighting to regularize this kind of water right because it's not according with the real water flow. And the last 5 years after that, the big mega drought that Chile are suffering, the people is fighting for groundwater exploitation. What's the means that? And the people right now is not getting water rights in the surface water flow. The people is trying to get more water rights from the groundwaters, and right now the people is fighting from the groundwater sources, and that is not fighting from the surface and water availability. So our main conclusion is right now the problem in the water conflicts in Chile is not related to the water market properly. It's more related of the capabilities and skills from the government to allocate the right quantity of water into the right water rights, to the capabilities and skill to resolve the problems and regularization, or in try to assess how much water the people can find into the groundwater. And finally, the people is not taking in consideration that the climate change and the water scarcity is driven by an physical phenomena, and maybe in the next years, maybe the regularization into the groundwater or the climate change issue could be maybe the main challenge for the government. That's with the actual and capabilities, maybe the government cannot resolve the problem. So our conclusion is a new water reform maybe will not resolve nothing in the future, because nor problem is related to the over allocation of the water rights, when the real physical water is not correlated for the quantity that the supply and change needed. Thank you.
Excellent. Thank you so much for that great presentation. We only have a few minutes left in our webinar, so I'm going to go directly to Professor Nico Sorensen. And thank you for your patience.
All right.
Excellent.
Can you
Thank
see
you.
my screen?
That looks wonderful. Yes.
Excellent. So hello from sunny Helsinki. My presentation is also based on an article published in the special issue, and as previous speakers, Stefano and Deborah were talking about the adaptive capacity of water law in the context of climate change mitigation and adaptation. My presentation deals with the adaptive capacity of water law in the context of biodiversity loss. And in particular, I'm looking at the conflict between hydropower, damming rivers for hydropower, and the impact it is having and it has had to migratory fish species, blocking the migratory up and downstream route for those species. And what I'm looking at is whether the Finnish legal framework allows a reconsideration of existing hydropower licenses based on new science and changed social ecological circumstances. And the reason I'm talking about this is not because we have a great system, but because Finnish water management and governance has in many ways failed. And I try to offer Finland and Finnish water governance as a cautionary tale how not to structure water management and governance in other countries. So I'll begin the presentation by giving a little bit of context on the hydropower and migratory fish debate, and after that move on to some of the historical, the societal, economic, and legal reasons why we got here. What are the reasons behind the 20th century hydropower boom in Finland, and what are the current legal issues that we're facing? And towards the end, I'll then be discussing how the social ecological context, the science, for one thing, has changed since the issuing of those licenses, and how we could move forward in reconciling hydropower and migratory fish. So if we look at to the picture on the right, prior to Industrial Revolution, Finland had some 25 free-running Atlantic salmon rivers and some 72 anadromous brown trout rivers, and 4 rivers in addition supporting both species. So roughly 100 rivers supporting salmon and trout. And currently, the number of free-running rivers with reproducing salmon and trout has been reduced to only 4. So from 100 rivers, we've gone down to 4 free-running rivers with natural reproductive cycles. And as a consequence of this, both anadromous brown trout and landlocked Atlantic salmon are classified as critically endangered, freshwater brown trout as endangered, and anadromous Atlantic salmon as vulnerable. And the complete loss of spawning habitat and migratory routes is primarily the result of large-scale hydropower damming. And if you look at the picture, the map on the right, all the red dots there are hydropower dams in existence. The damming of the Finnish rivers started in the beginning of the 20th century and in southern Finland, and proceeded from there to the rural northern provinces from the 1940s onward. Currently, as I said, almost all the rivers flowing to the Baltic Sea are dammed. So it is interesting to ask how and why did we get here? How did we lose our ecological flows almost entirely, and with that our migratory fish species? So before the 1930s, the Finnish Water Rights Act actually favored fisheries over power, and large-scale hydropower was all but non-existent. But as the demand for electricity for industries increased over the years, the interpretations of the Water Rights Act and the political pressure to revise it started increasing. Then the 1930s saw the dawning of a Great Recession, and by the end of the decade, Finland entered Second World War as a response to a violent Soviet invasions. And these circumstances led to the introduction of ad hoc legislation that established far-reaching exemptions to the then existing Water Rights Act. So between 1934 and 1941, the Finnish parliament passed 4 acts that lowered the criteria and the procedural safeguards for hydropower licenses. Gone were the due process rules, earlier ban on blocking a river's navigable fairway, and the substantive rules for issuing those licenses were based on a weighing norm, requiring merely that the benefits of a hydropower project must outweigh the harms. And they did so almost without exception. Altogether, these legislative changes resulted in roughly half of Finnish hydropower capacity being constructed based on this ad hoc legislation in a time of societal crisis. Now, the reason why past hydropower licenses continue to be a problem, and also a problem from a legal perspective, is that once a hydropower operation is considered in a public process and granted a license to operate, the license cannot be revoked or greatly adjusted without the consent of the hydropower operator. So the permits are eternal. The issued hydropower licenses are considered similar to buildings on land and granted permanence by the law. Furthermore, the licenses granted to hydropower operations are considered to reflect the private ownerships of the river flows. If one owns the property on which hydropower is produced and obtains a license to operate, the operation is protected by the constitutional property rights regime. So the main question then becomes, what reasons are there for reevaluating the permanence doctrine of hydropower licenses? What are the drivers of adaptivity? Why we are now discussing whether to change these existing licenses? First big reason is obviously change in context. So at the time when most of the Finnish hydropower was licensed, hydropower held almost 90% role in Finland's electricity production. This was in the 1950s and 1960s. But since then, if we look at the recent figures, they are somewhere around 20% of our total electricity production. And although the role, one might argue that the role of hydropower's combined storage capacity has increased somewhat due to climate change mitigation efforts and the development of fluctuating power sources such as solar and wind, it's reasonable to say that the societal importance of hydropower is substantially weaker now compared to its heyday in the 1960s, when it held 90% role of Finland's electricity production. So that's first reason for reconsidering the licenses. Obviously, the previous one is not legally a very strong reason, but here comes the legally valid reason, so to speak. The second reason stems from the EU and international legal frameworks, and the EU Water Framework Directive specifically requires that EU member states, Finland included, reach good ecological status or good ecological potential in all inland waters by 2015, or if postponed, by 2027 at latest. Now, the vitality of migratory fish populations is among the biological quality elements that contribute to the assessment of the overall ecological status under the directive. Furthermore, in 2015, the EU Court of Justice issued its famous Weser ruling, stating that the objectives of the Water Framework Directive are legally binding on the member states. Since then, the EU Commission has urged Finland to act for reevaluating existing hydropower licenses and restoring natural reproductive cycles of migratory fish. A regular revision of all water management licenses is, after all, mandated, required by Article 11 of the Water Framework Directive. In addition to this EU legal framework, the Helsinki Commission, established by the 1992 Helsinki Convention on the Protection of the Baltic Sea, has on several occasions expressed its concern for the state of Finnish rivers and recommended that some of the old hydropower operations be re-evaluated. Thirdly, and in addition to changing societal circumstances, the role of hydropower in the energy mix and changes in the legal framework, there have been major changes in science, what we know about the riverine ecosystems. And here's an interesting story. One of the overarching idea with the Finnish water legislation has been that the harm of damming for hydropower to migratory fish can be compensated by stocking the dammed rivers with farmed fish. Originally, the 1902 Water Rights Act favored fishways and fish transfers compensating hydropower harm, but from the 1950s onward, compensation practices started moving towards stocking rivers with farmed fish. And now the biologists and the geneticists are saying that while it is evident that the environmental impact of hydropower and the smolt production capacity of the impacted rivers were originally underestimated, research has also cast serious doubt on whether hydropower's harm to fisheries can be sustainably compensated by releasing farmed fish into the dam rivers. At the time of early dam building in the beginning of the 20th century, there was little understanding of the importance of genetic diversity, microevolution, or local adaptations in fish. Evolution was considered something that takes millions of years, though the current view is that ecologically significant genetic changes can occur in 10 or even fewer generations. Currently, it is not a scientific question whether hatchery rearing has negative genetic impact on fish. Rather, the question is how long hatchery breeding and the current restocking practices can support fisheries at feasible economic cost. So this brings me to the conclusions and the discussion. From the Finnish perspective, if I were to give some advice to other countries how to draft their domestic water legislation, first would be do not establish private property rights to water flows. Second, do not issue permanent licenses for hydropower operations. And do allow changes in science to penetrate water management and allow adaptivity. So the reason why the developing science hasn't been able to penetrate the licensing regime has been the property rights regime and permanent licenses. And we now know that the current stocking practices are unsustainable, and they deviate heavily from what we thought earlier, but still we haven't gotten that far. And currently, Finnish rivers are not in good ecological condition as required by the Water Framework Directive, and the situation, in my opinion, is not going to change considerably before EU Commission takes infringement action against Finland, and we are forced to kind of lift the permanence doctrine. But at the same time, there is a lot of discussion about an ecological offsetting regime, an idea that we would maintain some of the big rivers, the hydropower operations in our big rivers, while freeing up some of the smaller rivers to restore their ecosystem condition and the natural reproductive cycles of migratory fish. This is an appealing approach, as only a handful of rivers produce roughly 90% of Finland's hydropower at the moment. But the critics are, and rightly so, at the same time saying that this creates inequalities between the regions that still have the big hydro dams and the related ecological and other harms, social harms, and the benefits that the people, the riparians, gain alongside the restored rivers. So we'll have to see whether the ecological offsetting idea really has traction and some potential to solve the conflict. That's all for me. Thank you.
Thank you. That was a really great presentation. I love the way you were bringing in some questions around DNA and the permanence of these hydrological dams, hydroelectrical dams. I thought that was a different take than we've seen from some other speakers. So it brought a real depth to the panel. I liked that. Thank you very much. So we are here at about 30 minutes after the hour, which it would be the normal time that we'd like to cut off the webinar and finish it up. So if any of my speakers need to leave, if you have other pressing engagements, I completely understand. Otherwise, it'd be great if everyone who has time can stick around, and we can take a few questions from our panel or from our audience. If you're an audience member and you have a question, you can see it's just there's a box on your GoToWebinar control panel. If you just go ahead and type that in, it'll pop up on my screen, and I can direct it to the appropriate people. Just as a reminder, we're going to take all the PowerPoints that you saw here today and put them on our website. So if you'd like to just kind of review them or anything, I know people often ask, can I see them again? Can I hear them again? Both the webinar recording and the PDFs of our presentation will be on the website. So please just go there and give us a day or two, but they'll be there quite soon. In the meantime, while you're thinking of your questions, we have a poll for you to think about as the biggest barrier to using law to integrate science perspectives into policy. So I'm going to go ahead and launch that poll, and if you'd like to, go ahead and quickly respond while you're thinking of questions. Let's see, poll open. Okay, excellent. We are sending the poll out to everybody, and based on, this is based on your opinion, based on what you've heard here today, what you're thinking about, and I don't, can my panelists, can you see this poll?
I can see the questions at least.
You can see the question. Does anyone have an opinion about this biggest barriers? I mean, I know it's, if somebody says responsive, it depends or it's complicated, then I'll understand, but it'd be great, just any thoughts about that? What are some of the biggest barriers? Is it lack of awareness? Is there resistance to science perspective? Are the communities just too far apart? I see the response right now. It's fairly neck and neck. I'm a little surprised, to be honest. Give everyone here, we've got about 39% of you are still to respond. So if anyone out there wants to make a quick response, give it another second here. All right, I'm going to close off the poll. I'm going to give you 10 more seconds. Quick, get to the computer, tap the response. Don't think about it too hard. Okay, we're closing out the poll. All right, it's resistance. The resistance to science perspective by policymakers is what the majority of our respondents, 45% of the respondents, happen to feel that way. But 36%, which I think is pretty close, would say it's too large of a gap between the law, policy, and scientific communities. There's not enough overlap amongst people, I guess. but far less, 18% feel that it was a lack of awareness about law by the scientific community. So there's a good idea that there's awareness, but maybe the communities themselves are too far apart, or just that there's lack of resistance. And I think, using that kind of results, it'd be very interesting to see some work, perhaps qualitative, talking to policymakers and trying to kind of understand, what is the resistance, to try to kind of root that out. I don't know if it's a feeling of lobbies and subsidies and established players in the markets. There's an economic side to it, or if there's just a generalized resistance to science, preferring to focus on other belief systems. All right, well, let's see if there's any questions. I think maybe one question, so from the attendees, if you have the opportunity, go ahead and ask a question to our panelists. Go ahead and type it in there with the GoToWebinar control panel, and I'll see it. But it'd be interesting to hear my panelists kind of give their feedback on the poll. What did this make you think about? What do you guys think? What is some of the resistance that you guys have seen in your research? Anyone can just jump in, just unmute your microphone and.
Can you put back the slide, because I don't remember the answers.
We live in a very strange world here in North America right now, where there is little interest on the part of policymakers to take science into account. So it's not that there's resistance. It's simply we call it a post-truth politics kind of world. So it's based on ideology often, and it's also based on or decisions are based on ideology, and then also politics. So we have the science. I have lots of amazing colleagues who very clearly show what the scientific results are and where we need to go, and there's felt to not be the political will to implement that. And in Canada, unfortunately, it goes the other way, that we just simply don't have the science in a lot of the areas of water management where we need it. And so the policy framework and the legal framework are trying to, in some cases they're a best guess, in some cases they're simply trying to provide a broad framework within which discretion can take care of anomalies or site-specific requirements.
Sounds like someone has tenure. Anyone else have? I agree with that, but it's a troublesome situation of politics. It is. So, does anyone else have some feedback, input?
Right.
Yes, to jump right in. Stefano, I think you're muted. Stefano, take your mute off here. We can't hear you. Maybe I can unmute you on my side here. There you go.
Can you hear me?
Yes.
Okay. No, I was thinking that actually we all know, we experience that lawyers generally are a class or a profession that is sort of looked upon with some how could I say, with some concern, or by other by policymakers and scientists, especially scientists. They tend to look, in my own years of experience in FAO, where I worked, daily with colleagues from other divisions, the engineers, the hydrologists, I had to make quite an effort, to make sure that we sort of engage and understand each other on, and establish, I'm going to say, a common language. So there is a lot of, I'm going to say, a lot of resistance that I think is still at work from the scientific community towards lawyers. Lawyers are something, that are there to create problems, and they better be avoided at all costs, essentially.
Does anyone else have a question or a statement on this? Nico, go ahead.
Yeah, so what we see in Finland is that we have lots of great science. So and pretty much everybody agrees in the hydropower migratory fish debate that dams aren't good for ecosystem functioning and migratory fish. That's everybody accepts that reality, but there's a lot of institutional and legal path dependency when the hydropower operators have had such a legally protected space and the benefits for such a long time. It's really tricky to figure out where to begin, and when you have that element of constitutional protection, it's always always a question of whether you need to compensate to the hydropower operators if you demand fishways or demolition of dams, and how much will the compensation be, and questions like this. So there's a little bit of timidness there, and we're starting to slowly move to that kind of ecological restoration and bringing back the ecological flows that the Water Framework Directive is requiring from us.
Well, I appreciate those kind of comments from everybody. Does anyone else have a comment or follow up on that, or should we go to the question that we have here? Oh, we can jump to the question. Renee Martinegel, who is a IWRA board member, and I believe she's on AIDA as well. I know she's a water lawyer, has a question. She says, we have heard about local and national efforts to manage and govern water resources. Do the panelists think the best approach should be local, regional, national, or international? So it's a scalar question, kind of what's the best approach, how to go forward. What does the panel have to think about that?
Can you repeat, please, Scott?
Yes, so she was just asking, given the situations that we've heard here from today, what is the best approach, scalar approach? Would it be local, regional, national, or international? And no saying it's complicated or anything like that. Let's give a real quick.
It is. There's not one answer, actually.
Oh, no, we can't have that.
It's a case by case answer. I mean, and it depends on what decision you are taking. Some can be taken at a very local, but they would be in a broader context. I mean, if I think of a transboundary water resource, you have the transboundary water resource where we have the cooperation framework. Then we have this transboundary water framework which take decisions, and then you go down scale by scale, like these doors that like go. There's these Russian doors. One is fits in the other. There's no. I mean, from my view, there's no one answer. The broader scale takes the policy decision, and then the very practical decision can be taken at a very, very small scale or not. It depends.
Okay, that's good. What do some other people have to say?
It depends on the scale of the problem. It depends on the scale of the issue, the scale of the problem. So it's I agree with Raya entirely. Well, we all know, and there has been a lot of talk about the beauty and the advantages of river basin, the scale of river basin for the proper management of water resources. Okay, fine, that's fine. But again, there are issues that are best dealt with at the local level, communities involved when the issue is local, and others that are better scaled up at the national level when there are national policy issues that get involved, and the transboundary when it comes to transboundary, issues in rivers and lakes and groundwater. It depends.
I think
there are some broad ecosystem parameters around ecological function that can be set at the highest level, so that then the local decisions, no matter what they are also reflecting that continued functioning or proper functioning condition. So, if one could consider the EU Water Framework Directive as that particular thing that then very much trickles down, or should trickle down, to the local level, because in anything, whether you're making land use decisions or water decisions, politics always gets more intense and personal at the local level. So as much as you can provide a more generic but yet prescriptive ecosystem standards at a higher scale, then you need to abide by that at a local scale. And I'll just give you an example from British Columbia, where we used to build right to the edge of fish-bearing streams. And most of you know, the salmon industry and the amount of salmon that we produce in BC is incredible. Produce as in our landscape, the salmon come back, they spawn, and then they go back out to the ocean. It's really remarkable. It's an internationally important function, ecological function that we provide. However, we used to be able to, local governments would allow you to build right down to the stream. Because that was such a highly contentious matter about private property rights and what you could do with your private property rights, the provincial government, pushed by the federal government, enacted the riparian areas regulation that requires a setback. And so you start with a 30-meter setback, and there's some wiggle room within that. But that is an example of, in order to maintain ecosystem conditions, you take that decision-making away from the local level by requiring certain ecological or functioning conditions.
I agree with that. Sure.
Nico, did you have something to say, or?
Makes sense.
Agree with pretty much everything. Yeah, the only general comment is that, obviously we're moving more and more towards this watershed or drainage basin wide approaches, and we need to look at all the sectoral impacts and pressures overall. But other than that, it depends on the problem we're dealing with. And as Deborah said, as is true with the EU, it's rather easy to set these ecological goals, even binding ones at the EU level. But once it goes down to the question of whether we are going to revoke an existing water license from a hydropower operator or something like that, it becomes tricky. It starts to hurt. It starts to politicize. But that's the level we need to take it to, because otherwise those noble goals, they're not going to function. That's going to be tricky.
All right. Well, if no one else has anything else to add, I think we're about 15 minutes over the timeline we had given, so I'm going to go ahead and shut down the webinar. And just want to thank everybody on my panel for joining us here today. Rhea Stefan, Nico Sorensen, Deborah Curran, Alex Godoy-Fardez, and Stefano Berci. Thank you everyone for joining us here today. I know that some of the panel and IWRA are on Twitter, so please give us a follow and go ahead and engage with us there on the social media. Retweet. We will be certainly recapping this event on Twitter, so retweet us, like us, as it were. And if any of these presentations left you wanting to learn more, you can go right to our LinkedIn webpage and continue to follow the discussion and to follow IWRA and hear about more of our updates as we lead up to our next Water Congress in 2020. If any of these insights, provided you a lot of things you want to talk about and think about more in the research, please make sure that you go to we will be sending you, if you are attending to us live, we'll have the special issue. This special issue will be made open access for you for the next month. We'll be sending you the link tomorrow, I believe. So please download all the articles. Read them, cite them heavily in all of your work, and we would appreciate that. And we thank our generous publisher, Taylor and Francis, for their help with that. Just to remind you, this webinar is brought to you today by the International Water Resources Association. We are an over 40-year-old nonprofit, non-governmental educational organization focusing on bridging disciplines and geographies, connecting professionals, students, individuals, corporations, and institutions who are concerned with the sustainable use of the world's water resources. So if you're interested in knowing more about the association or becoming a member, you can go to www.iwra.org, where you'll also find recordings of this webinar and PDFs of all the slides, so you can watch it again and again as much as you like. On behalf of the whole IWRA office, thank you for watching the webinar. Thank you very much. Have a good day.
Thank you, Scott.
Thank you.
Goodbye, everybody.
Bye.
Bye-bye.
Bye.